All right, good afternoon, everyone. We're back with David Korman's great informative webinars. After a break of the summer, it's still great and beautiful outside. We were just talking about that. Thanks for joining. We will be recording the session. If you have any questions, hold them till the end of the the webinar. And over to you, David.
Okay, well, good afternoon, everybody, and thanks for joining us. Those that are going to be listening or watching this live, and those that might see it later on in recording. Either way, hopefully this will give you some good information for your toolbox and help you potentially deal with your clients when they're interested in buying a property that's subject to a power of sale, being sold under power of sale, or dealing with the foreclosures. So my hope for the next hour or so is to give you some information that'll be useful to you to help you understand the general process. And so I guess we should start with the fact that, well, first of all, like Sabiha said, it's great to be back. And I think, we finished off doing these in June and the market wasn't great and people were sort of taking a break for the summer and everybody was saying, oh, yeah, but you know what? Labor Day's coming. It's not that far away. And right after Labor Day, there's going to be a busy fall market. So I hope you're noticing an increase in activity out there. Encourage your clients. There are lots of opportunities. One of the opportunities that does come up more these days than it would have 3 or 4 years ago is properties that are being sold under power of sale. So that's why we're going to talk about this. There's been, I don't have the actual statistics in front of me, but there's been a substantial increase in the number of properties that are being sold under power of sale. It's not rocket science as to why. A lot of it simply is because of the current economic conditions that we're in and the economic conditions that we came out of. So we went through an extensive period of time where interest rates were historically low. And there are so many, somebody's got to mute their phone, please. Thanks. So historically low interest rates, when interest rates were hovering around 2%, you have to appreciate, and those that are more veteran in the industry certainly know this, that those weren't a norm, even though it lasted for an extended period of time. That was really an anomaly in the market. Historically low interest rates for a lengthy period of time, and there was a whole bunch of buyers, first-time buyers, second-time buyers, people that bought properties to take advantage of those low interest rates, and you all benefited from all the transactions that we were doing in those days. So people bought their properties, 2% interest rates and things like that on 3-year, 5-year mortgages that have now come up for renewal. Those mortgages aren't being renewed at those rates. The rates have been much higher. Some have had to pay, 6%, 8%. At the very least, they're doubling what they previously were paying their mortgages. Sometimes the same property they've been living in for 3 years, 5 years become unaffordable. So you got that factor in there. You've got the other economic uncertainty right now with the tariff situation with the US, et cetera. The economy's generally sluggish, and people are insecure about their work situations, their income situations, and some people are in fact losing their jobs and can't afford the houses that they have been living in, and some of these properties get underwater. So having said all that, there's a number of factors that lead to properties going into power of sale, but the bottom line is a lender has given a loan to a borrower, a homeowner. We're going to talk mostly about residential power of sales. There's commercial power of sales as well, but it's basically a lender, whether it's a bank, a trust company, a private individual, whatever that lender is, they've given a loan to somebody to buy a property or to refinance their home. And at some point, for one of these economic factors or other factors, and it could include just mismanagement by the homeowner of their personal finances, they go into default and they get behind and they stop paying. Now, under our laws, when you grant a loan, generally the lender wants security. The main security on real estate that the lenders receive is putting a mortgage, registering a mortgage on title to the property. And the reason we do that is when there is a default, one of the remedies that a lender has to recover the money, the principal, interest, penalties, other costs they've incurred in the process, one of the ways of doing that is to be able to have the right to sell that property. And that right is what we commonly refer to as the power of sale. So in the Mortgages Act and in mortgage documents themselves, the borrower is always granting the lender the right to sell the property under power of sale if there's a default. And lender has to follow certain procedures in order to do that. And we're going to discuss some of that in a few minutes. And the reason I said it's one of the remedies because it's not the only remedy. A lender could simply decide to sue the borrower and try and get a judgment and collect that way. Another option they have is to foreclose on the property. And I'm not going to spend a lot of time talking about foreclosures because it's not that common a remedy these days that's being used by a lender. But just to understand the difference between a power of sale and a foreclosure before I actually get into my slide presentation here. So a power of sale is the right of the lender to sell the property. They have to give certain notice. They go through a process and they can sell the property and then use the proceeds from the sale to pay whatever debt is outstanding to them. If there's more than just their debt from the proceeds, then they have a duty to account to other people that might have interest in the property. And I'll get into that a little more as we go through the power of sale process. A foreclosure is a different right of a lender. It's a right of a lender to say, okay, this property is in default. Instead of me selling the property, I want to take over legal ownership of the property. And that's what's going to satisfy the debt that's owed to me. I'm going to become the owner of this property. So I'm going to foreclose the interest of the current owner. I'm going to get registered title to myself, to the lender. And then once I own the property, I could do what I want with it. I could sell it. I could rent it. I could refinance it. I could do what I want. It now becomes my property. I've now exercised my right to on that security that way. So foreclosures are not that common right now in current market conditions. We see it the odd time, sometimes in more rural settings where there might be a really down market and it's not a good time to sell a property. And maybe the property's got a lot of disrepair or something. The lender says, if I sell it right now, I'm not going to recover all my money. So I'm better off maybe foreclosing, taking ownership. I'll put some money into the property, fix it up. Maybe I'll rent it. Maybe I'll wait for a better time, better market to sell it in and try and recover that way. So there is some foreclosures that happen, but more often than not, the remedy of choice would be a power of sale. So I want to get into the actual slide presentation now that I've given you that long-winded introduction. So I'll skip through our introductory slides. Most of you are familiar with where we are and what we do. And this is a topic that David Gorski and I have discussed on a few occasions in our podcast. So you can always check out some of our discussions in there, the David and David and Real Estate podcast. So please check that out. So when we're talking about power of sale, I've already mentioned that there's certain processes, procedures that have to be followed. And I want to go through some of this because ultimately we're going to discuss a little bit like some of the pros and cons that in your decision making and the advice that you're going to be giving to a potential buyer that might be considering buying a property under power of sale. So like, is it a good idea? Is it a bad idea? What are the pros and the cons, the advantages and disadvantages? So in order to get to that, you have to really understand the process a little bit more, okay? And it starts with the lender has certain obligations when they're selling under power of sale. A lender and I could just use a monetary example because it might make it simpler. Let's say the property, it has a fair market value today of $1 million. Let's say the lender had a mortgage on it for $700,000. So there's $300,000 in equity, just to put numbers to it. So that mortgage is in default. The lender is owed $700,000. Maybe there's some outstanding interest. Maybe there's some penalties. Maybe the lender had to pay property taxes to keep up to date or pay for insurance costs or legal fees. So there might be some additional costs the lenders incurred above it. So let's say there's $50,000 in those type of costs. So the lender wants to sell this property for $750,000 to break even, right? To get all their money back. So if they sell the property for $750, they get all their money back. So that's great. But the fair market value might be $1 million today. So the lender has an obligation to not just sell it at a price that's enough to get the lender's money out of it. They have to take reasonable precautions to get a true market value when they're selling the property, when they decide to sell that property in whatever market that happens to be. So if in today's market, if they're selling it today and all evidence would show that it has a value for $1 million, they got to take reasonable steps to get $1 million for this. They'll pay themselves the first $750, but there's another $250,000 in equity, and that $250 belongs to somebody. Maybe there's a second mortgage holder on it. Maybe there's a lien claimant. Maybe it just goes back to the owner of the property. But they have to account to everybody else that might have an interest in this property that's behind their mortgage. So the first thing a lender has to do is make sure they take reasonable steps. So most lenders will get at least 2 appraisals and try and figure out what a fair current market price is when they're selling the property. And that's why they'll choose usually not to sell to just a related party, because someone can look and say, you know what, I know this is in default, you're owed $750. You know what, I'll tell you what, I'll give you $800,000 for it. You don't have to go through this whole process because I know about this and I'm related to the owner. The answer is they're not going to do that, because even though the first mortgage lender gets their money out of it, they're going to fail in their duty to account to everybody else that might have an interest, because they can challenge that lender. Why did you sell it to a related party for $800,000 and defeat the interest that I have as a second mortgage lender or as a lien claimant or as the owners of the property? You just cut out all my equity. So lenders are not going to do that. They're going to go through a process. So they've got in their file evidence that they tried to get a reasonable amount for it. And in case I forget to mention this later on, I mentioned that they have to look at the value on the date that they decide to sell it. So if it's in default and they followed the procedure that they have when selling under power of sale, which includes giving notice to everybody that has interest. Okay. You can't sell under power of sale till you've given everybody that potentially has an interest in the property notice, and they have an opportunity to redeem the mortgage, which I'm going to talk about in the meantime in a minute. So you followed all the procedure, but you could sell the property today, but sometimes a lender will say, you know what, it's September 2025. The market is sluggish right now. I don't want to sell it right now. I'd rather wait because maybe I won't get all my money out. So I'm going to wait. Maybe I'll sell it in November or December. So they can do that. That's up to them. They can make that decision, and they can't be challenged on when they would sell it. The owner can't say, hey, why did you sell it in November? You could have gotten more money in September. The lender has the right to choose when they want to sell the property, because the borough and other people in interest have other ways that they can approach this. Okay. If they don't like the fact that the lender's waiting to sell it in November, they could try and sell it themselves. They could try and redeem it, put it in good standing. There's other things they can do to protect their interests. Just wanted to make that point. Now, I do want to talk about this concept of redemption, because it's a really important concept when we're talking about selling under power of sale. And this comes from the Mortgages Act itself. And it gives it's the right of anybody that has an interest in the property after they receive notice that the property is going to be sold under power of sale. It's the right of them to redeem or put the mortgage back into good standing and or pay off that mortgage to stop the power of sale process. So most lenders will include language in their agreement of purchase and sale that allows the lender to accept redemption and have a payout of the mortgage at any time prior to closing. So what's important for you to know, let's say you're acting for a buyer and you've worked hard and you found this property and you've now got a firm agreement of purchase and sale to buy this property from a lender who's selling the property under power of sale. There'll be a clause in that agreement, usually in Schedule B or C of that agreement, when they're selling a power of sale, that makes it clear that if the property is redeemed by somebody that has the right to redeem it, then this agreement of purchase and sale will be terminated. It'll be null and void. So even though you got a buyer that put a deposit out and is planning to close soon and doing everything right, the rug can be pulled out from under them at any time. They would get their deposit monies back. There's no issue with that. But if the borrower or somebody else finds the money to redeem and put it back in good standing before the transaction closes, then that will terminate the agreement of purchase and sale that you have worked hard on, and your client is so excited to move into this house, and now they pulled the rug out from under them. They had the right to terminate, they terminated, and deal's off, and you got to go find them another property. So it's important for you to understand that. Now, when an agreement of purchase sale is entered into for a property being sold under power of sale, if the property was owned by Joe Smith, and Joe Smith was the borrower, and he's in default under the mortgage, and the lender's going to sell it, and the lender is Bank of Nova Scotia, or the lender is private mortgage company, whatever, the lender in your agreement of purchase and sale is not going to be Joe Smith. It's not the owner of the property. The lender is going to be Bank of Nova Scotia under power of sale, or a private mortgage company name under power of sale. That's who's selling the property. It's not being sold by the registered owner of the property. It's being sold by the lender under power of sale. And that's an important concept, and make sure your agreements of purchase and sale reflect that. Okay. Now, I wanted all of this to lead into your thoughtful process of helping your client determine whether they're really getting a bargain if they're buying a property under power of sale, because there's arguments that can go both ways. And a lot of times, properties that are being sold under power of sale might be sold, or people think they're being sold at less than a fair market price. So people think, oh, let's look at some power of sale properties because we can get a bargain and we'll get it at less than fair market price, and and our client's going to be way ahead of the game. So there's some arguments against that. So first of all, remember, it is the lender selling the property and not the registered owner selling the property. So the lender doesn't know the physical condition of the property. They didn't live there. They don't know where all the warts are and all the deficiencies are. They're not familiar with it. So when they sell it, they're going to be selling it as in an as-is, where-is condition. The lender will not provide any representations or warranties about the condition of the property at all. Okay. And it'll make it clear. And usually there's a Schedule C that has a bunch of specific power of sale type clauses that'll be added to the agreement of purchase and sale. And it'll make it clear that there are no representations and warranties from the seller for anything, that the buyer's accepting the property, it's being transferred to them pursuant to the Mortgage Act, because there's a default. So they will provide a statutory declaration. The lender, when I say they, the lender will provide a statutory declaration as the seller to confirm that there was, in fact, this default under the mortgage, and they have the right under the mortgage and the Mortgage Act to sell the property. That's about all you get from the seller, who is the lender. But they're not going to give you any rep or warranty that title, what's the title is good, whether it's subject to easements, rights of way, encroachments, anything else. Buyer has to completely rely on their own inspection of the property. They're going to accept the property as is, whether there's work orders, deficiency notices, zoning infractions, doesn't matter. Seller doesn't know if in fact any of those exist usually, and they're not going to help you out if they do. You want the property, sign an agreement, you're going to get it as is. Okay? So you have to keep that in mind when you're trying to determine, are they really getting a bargain? Because there might be a whole bunch of deficiencies in this property, like physical deficiencies in this property, and that's going to cost certain amounts to fix it up. And so the potential buyer has to have a budget to fix those things. And some of those things won't be known on closing. Now, they may have had an inspection, so they may get a better idea of what really has to be fixed and make sure that your client has a proper budget to do those things. But that's an important consideration when you're buying under power of sale. Now, you're not getting any rep or warranty on soil conditions, urea formaldehyde foam insulation, environmental matters, or anything else. The Schedule C will also have a right of the seller to terminate the agreement if an injunction or another court application is brought by a party that restrains the sale. So again, your client's at risk for having the deal terminated. And I've already mentioned they have the right to terminate if somebody that has an interest in the property redeems and puts the mortgage into good standing or pays out the mortgage prior to closing. The lender, who's the seller, is not going to give you any help about any tenancies. Usually, if there's tenancies there, you're going to say you have to assume any tenancies, and we'll give you some information that we have, but we're not giving you a rep or warranty as to what the rents are or how much they've paid or things like that. So they make life difficult if there are existing tenants there. They're not going to give you any warranty about the chatters and fixtures, whether they're in good working condition or they're not good working condition. They won't even give you a warranty that the seller has the right to sell those chattels and fixtures to them, because the lender doesn't even know if the registered owner, in fact, owned all of those chattels. They may have been subject to a financing agreement or something like that, and the lender doesn't even know. So on closing, the seller's going to say, I'm assigning and transferring to the buyer whatever right or interest I might have as the lender on this property in those chattels and fixtures, but I don't even know what that is, because it's possible that someone could show up and say, hey, that HVAC system that's in there, it wasn't owned by the owner. It was owned by us, the financing company, and we're pulling it out. So that's an important consideration as well. Now, another thing that's sort of unique to power of sale process, and the Schedule C agreement purchase and sale usually has a clause, it'll give the seller usually the option to extend the closing date for up to 90 days is sort of common in order to resolve issues that might come up in the power of sale process. So that's important for your buyer client to know of. Like, you might have a closing date of September 30th and everything is moving towards that date and they're planning their move and getting their financing and doing all the right things. And then all of a sudden you get a notice from the seller saying, hey, we have to go to court to resolve a certain issue, or we got this, and we're going to exercise our option to extend the closing by 30 days, 60 days, 90 days, whatever they're allowed under the agreement, without terminating the agreement. So your buyer client has to know that they might have to stick around for a period of time because the transaction just got extended. So for some buyers, that might be fine. For other buyers, they might act for that's just not, that could be a deal breaker. It might not be acceptable. HST, as you know, is generally not payable on used residential properties. But you're not going to get any help from the seller, who again is the lender, to determine whether HST could be applicable, because there are certain residential properties where HST is applicable, in particular for a residential property where there's been a substantial renovation and it crosses a certain threshold and it's treated like new construction. So sometimes, you might be looking at a property that was extensively renovated and is now being sold under power of sale, and there's a question of whether or not HST is in fact payable on that. So just keep that in mind, because that's got to be determined as well. And the seller's not going to give you a lot of help because they may not have the information to help make that determination. Now, most of you know, when you're dealing in the resale market, that sometimes things come up after closing. Certain deficiencies become apparent after closing, and sometimes the buyer has the right, even after closing, to go after a seller in certain circumstances. And we've done webinars and seminars on this topic with your office before. It depends if it's a latent defect, a patent defect, did they take steps to hide it, did it affect the ability of someone to live safely in the property. There's a number of factors, etc. But sometimes a buyer has the right to go after a seller after closing for deficiencies that they weren't aware of at the time of closing. That is not the case when you're buying under power of sale. The seller has no obligation or responsibility after closing for any issues that come up on conditions of the property. So again, buyer has to understand that your buyer has to be clear on that, that if an issue comes up after closing, that there was a leak or there was whatever, some contamination, some mold, they can't go back after the seller. The seller didn't know about it. Seller didn't live in the property. Seller didn't do anything to hide it because the seller is the lender. It's not the property owner. And the agreement of purchase sale makes it clear that there's no obligation or responsibility of the seller after closing. So you have to make sure your buyer is going to accept that risk as well. So all of these factors, the physical condition of the property and everything, leads partly to that discussion of, is it really a bargain? Because maybe you're getting it at a little bit below what you think is fair market price. Maybe it's 50, you think it's worth a million, but there are these deficiencies. It might cost your client about 50,000 to fix all of this. So if they buy it for 950, it's a bit of a bargain. They might be putting back that 50,000 in, and effectively it's costing them $1 million for that price, that property. So they might not be getting quite the bargain they thought they were getting. And it also goes to my first argument. The lender can't really discount these properties by a large amount below fair market value because they have the duty to account and sell at a reasonable price and have evidence in their file that they got a reasonable price in the market that they were selling. So if all evidence shows that they should have sold for something close to $1 million and they just decided to accept 800,000, that exposes the lender. So you're generally not going to get it at that much of a discount. You might get a little bit of a discount because for market conditions, because the reluctance of a lot of buyers to buy a property under power of sale. So that might just push the price down a little bit to a certain point. Okay, because there aren't as many buyers that are prepared to buy a property with these kind of risks and unknown and inability to go after a seller and to be able to risk whether the property could be redeemed or whether the transaction could be extended. So that'll just eliminate some buyers from looking at this property. So that might help push a price down a little bit below a fair market price, but it's only going to go so far to a point that's going to make the lender a little uncomfortable that maybe they're selling it for too low. So it's all something that has to be factored in to your decision making, the advice that you give to your potential buyer client. Now, when you're signing an agreement of purchase and sale and a power of sale, the form of agreement is going to be different. There's certain changes that have to be made to a standard ARIA or TREB agreement of purchase and sale. So I'm just pointing out a couple of them in these that these are changes that are going to be made to the pre-printed form. So Section 8 in the pre-printed form has a title search clause. And part of that's going to be deleted that refers to the buyer being satisfied with work orders, deficiency notice, use of the property. That's generally going to be deleted because it's not going to be conditional on that. The buyer is going to accept the property subject to those things. Section 12, which is a title clause, is usually deleted in entirety because there'll be a different clause in Schedule C that's going to deal with title and title matters and how title is going to be conveyed because it's being conveyed by the right of the seller, who's the lender, to sell it under power of sale. So it's a little bit different. Section 12, which is the inspection clause, is usually going to be deleting the part that talks about the seller delivering a survey. And simply because the seller usually doesn't have one, or if they have one, they don't want an obligation to give it. It's probably an old survey. They're usually deleting that. There's usually a change to Section 14, which is the insurance clause, which is going to delete a lot of it, except that the property will remain at the risk of the seller until closing. Section 22 in the printed form is the ARIA formaldehyde foam insulation clause. That's usually deleted because the seller's not going to provide a warranty that there's never been any ARIA formaldehyde in there, just like a normal seller would. Spousal clause is not applicable. You don't need a spousal clause or the completion of spousal clause. If Joe Smith owned the property, we don't need Joe Smith's wife to consent to this and sign a spousal clause, spousal consent, because Joe Smith is not selling the property. It's being sold by the lender under power of sale. So we don't need the spousal consent. And some of you might say, well, like, what about the spouse's interest? What about Mrs. Smith? Doesn't she have an interest in this property? And that seems unfair because her protection, like Joe Smith couldn't sell it himself without getting his wife to consent to it. So how come a lender could sell it and poor Mrs. Smith is left in the dark? Well, in fact, Mrs. Smith is not going to be left in the dark. She's going to know about the whole process because when the notice of sale under power of sale is issued to Mr. Smith, there's a statutory requirement that the spouse of Mr. Smith be served with the notice of sale as well, because she has an interest in the property. And once she gets notice, she has the right, if she so chooses or has the ability, to redeem the mortgage as well. So she is going to be protected by the power of sale process because she will get notice as well. And she'll be served with that notice of sale under the mortgage. I should mention, because I don't know if there's a specific slide that comes up on this. When a notice of sale is issued, like if there was a default, usually the lender doesn't issue a notice of sale right away. Usually a lender will send a letter, a demand letter. Hey, you missed a payment, you're in default, give an opportunity to fix it, see if there's an attempt to or not. But and sometimes that letter might say you got 5 days, you got 10 days or whatever, failing which we're going to exercise our rights under the mortgage. So once they get past that and they decide, okay, they're not doing anything, haven't heard from them, can't find them, or they said they're going to do something, they didn't do it, we've given them enough time, now we're going to issue a notice of sale. So the notice of sale itself gets issued to the registered owner, it gets issued to the spouse of the registered owner, it gets issued and served on anybody else that has an interest in the property. If there's a second mortgage lender, third mortgage lender, a lien claimant, anybody else that's registered, has a registered interest in the property, everybody receives the notice of sale, which gives them the right to do something about it and redeem it. Now, the notice of sale gives everybody a statutory 35-day period in order to do something. And during that period, the lender can't do anything. He can't take any further steps. He's got to sit back, can't sell the property till the expiry of that period. Once that period expires, then the lender is in a position to take the next steps and and list the property, sell the property, accept agreements of purchase. They'll do what they want. Okay, so everybody that has an interest in the property has this time period where they can figure out what's best for them or whether they can redeem or put it in or pay out the mortgage or whatever. Okay. Now, this is important for everybody that gets notice. And we see this a lot of times. Let's say a second mortgage um, lender gets notice of that the first mortgage ahead of is in default. Like their mortgage might be in default too. Maybe they're also going to issue notice of sale, or maybe their mortgage is still in good standing, but now they know the mortgage ahead of them is in default. So they know that lender could sell the property. And when they sell it, they'll pay themselves. And then they have to account to the second mortgage lender, and maybe there'll be money there. Sometimes a second mortgage lender says, I'd rather take control of the process. So I'm going to pay the first mortgage lender, put that mortgage in good standing, keep it going. And by doing so, there's a default in my second mortgage, and I can sell the property under my second mortgage and take over the process, or I might choose to foreclose or do something else. So anybody that has a subsequent interest has that type of right, and sometimes we see them exercise those rights. Now, if the second mortgage lender sells the property under power of sale, they have to pay out the first mortgage in full, principal, interest, whatever is going to show up in that first mortgage lender's statement. They get paid out in full before there's any money available for the second mortgage lender. Then the second mortgage lender can pay down their debt. Maybe they get paid in full. Maybe they don't get paid in full. Whatever. If there's excess funds and the second mortgage lender gets paid in full, then they've got to account to anybody that's behind them. Maybe there's a third mortgage lender. Maybe it's just there's money that's going to go back to the registered owner of the property because there was additional equity. So that's sort of the way the system works in terms of the notice of sale itself. Now, I mentioned a little bit before on tenancies and occupants, and generally lenders, don't have a ton of information or updated up to date information on any tenants that might uh, be living there. So lenders oftentimes are not going to be agreeable to providing vacant possession on closing. They're going to say, I'm going to sell the property subject to the tenants that are there. So that has to be dealt with. If there's an attempt to get rid of tenants or the buyer wants the tenant out, oftentimes they're not getting a lot of cooperation from a lender. The lender might say, no, no, you buy the property subject to the tenancy. If you're really going to use this property for your own purpose and you want to get rid of the tenants, then you can give the tenants notice yourself after closing that you want it for yourself and go through the Residential Tenancy Act provisions and notice provisions and do it on your own, but the lender doesn't want any part of it. So you have to be aware of that. And any property that's being sold under power of sale when there's tenants, it could be problematic. Now, sometimes there's an agreement in writing for the tenants that they're agreeing to leave. Maybe they've negotiated an agreement to leave. Maybe they're being paid something to leave. Who knows? So those type of issues come up. So you have to be aware of them. And oftentimes you're getting very limited cooperation from a lender to deal with tenants. So just be aware of that. Couple of things I want to just touch on a little bit. Some of you might be aware of what a notice of security interest we refer to as a nosy is. So there are certain things in a residential property that may not be owned by the owner. And this is oftentimes it's an HVAC system, a water purification system, furnace, things like that. And sometimes those are financed. So when they're financed, there's usually a registration under the Personal Property Security Act to register that as opposed to registering it on title on the real estate. Now, sometimes it's registered in both. Sometimes there were these notice of security interest registered on title to the property as well. Now, if there was something registered on title, that would not be deleted by a power of sale process. A mortgage will be deleted. If there was a first mortgage lender selling the property and there was a second mortgage, when the title is transferred from the lender to the new owner, that second mortgage and the first mortgage that was sold, those are going to be deleted completely from title. They're wiped out. Okay, those mortgages are no longer registered on title. Second mortgage lender may have gotten money, they may have gotten paid out in full, they may have got partial payment, they may have got nothing, but their mortgage is going to be deleted from title. So the buyer is always going to get clean, clear title. Okay, a notice of security interest would generally have priority over that, would not be deleted by a power of sale process. Now, it can be deleted by court order. There's other ways to deal with it. It's just something that comes up. Now, there was an amendment in the Homeowner Protection Act that it's just a little over a year ago, June 2024, that bans the registration of these nosies on title. So they're no longer registered on title anymore. They can still be registered in the Personal Property Security Act, but they're no longer registered on title. And the amendment to that act, in fact, deems that any nosies that are registered on title are deemed to have expired. So they can be deleted from title, and whether they're on title or they've been deleted from title, they have no effect on the title because of that change. So there's no longer a security interest registered on title. Anybody that lent money for that type of equipment still can secure it against the original owner with a notice of security interest registered under the Personal Property Security Act, but no longer on title. Anyways, that's legalese, and that's why you have a lawyer acting for your client to make sure they deal with these type of issues and make sure, because we always want to make sure that the new buyer, new owner is going to get clear title. Okay. And they will get clear title from the power of sale process because all of these interests that are subsequent to the lender's interest that's selling it, they all get wiped out. They all get deleted from title. And the reason they all get deleted from title is because all of the parties that had an interest get the notice that it's being sold under power of sale and they have an opportunity to do something about it, failing which is the redemption right, failing which their interest gets deleted from title. Now, that doesn't mean they don't have rights if they're still owed money by the original owner. They may have other rights. They might be able to just sue that owner. They might have other security, but they no longer have a security interest in this piece of real estate because their mortgage is being deleted from title. Okay. It doesn't delete their right to go after a borrower the original owner that might still owe them some money, but they don't have security of this piece of real estate for that any longer, which is why sometimes a second mortgage lender wants to get control of the process and pay out a first mortgage lender or put them in good standing and just try and get some control that way. But you should be aware of it. So you don't have to worry about whether your client who's buying the property is going to get clear title. On closing, they're going to get clear title. They're going to be able to put their own mortgage on title, which will be a first mortgage, and everything else is going to be cleaned up with this process. Okay. Construction liens have to be dealt with as well. So sometimes a construction lien claimant can be claiming priority over some of a mortgage. Again, this is something that a lawyer is going to be dealing with to determine that on closing. So just to give you a simple example, sometimes the loan that the lender was making, maybe it was to finance the construction of a renovation or something like that. So maybe they're putting a mortgage on for 700,000, but they're not advancing the 700,000 all at once. They're advancing it in stages as the construction progresses. So let's say they've advanced 500,000 and then a lien gets registered on title and then they advance the other 200,000. That lien claimant can claim that they have priority over that $200,000 advance that was made after their lien claim rights arose. So sometimes that type of issue has to be dealt with. Again, make sure that your clients have good legal representation on these things. If it's a condominium that's being sold under power of sale, liens for arrears of common expenses that are registered under the Condominium Act will not be deleted from title, which means that they have to be dealt with another way. We don't want your buyer to buy this condo and has this outstanding amount owed to the condo corporation for common expenses. So the lawyers involved are going to make sure when that becomes apparent that there'll be funds directed to pay out any common expenses that have to be paid out in order to get rid of that. Sometimes there's a certificate of pending litigation that's registered on title. And, and that could be done by a number of parties that have an interest in the property or just have a dispute or monetary dispute with the owner. They may have registered a certificate of pending litigation because they started a lawsuit. So that's not deleted by the power of sale process. So if something like that shows up on title, then a court order is required to delete it. So somebody, the seller, who's the lender, would have to apply to court, try and get rid of it. Sometimes the parties will come to terms and negotiate a settlement to get rid of it. So the court order or the certificate of pending litigation can be deleted by the consent of the party that registered it. Again, make sure they got good legal representation and issues like that are dealt with, because bottom line is we want to make sure that the buyer, whoever buys the property under power of sale, is going to get clear title and not have any outstanding issues with construction liens, certificates of pending litigation, condo liens, whatever the case may be. We want to make sure they got clear title. So I think with what I've talked about so far for the first 45 minutes will probably give you a pretty good understanding that the process is different. The risks are different when you're buying a property or clients are potentially buying a property under power of sale. So that doesn't mean it's a bad thing. It's just different. So you have to understand the differences and you have to be able to explain to a potential buyer through your help, your assistance, and through the lawyer that you're going to advise your client to use to help guide them through the process and understand the differences and the different risks. And at the end of the day, it might be a bargain. They might be able to get the property at something less than fair market value. But again, you got to factor in the potential risks of the unknown, and your clients have to have a budget to fix things up. I mean, if they do an inspection and the inspection shows, oh, you know what, there's a leak over here, and and the roof has to be fixed, and we need the electrical systems needs to be repaired, and whatever. There could be a whole laundry list that comes out of an inspection. So in a normal resale transaction, you do an inspection, you get that laundry list, you would go back to the seller and say, hey, we're not prepared to buy this at $1 million anymore unless you either fix up all these things before closing and give us evidence to our satisfaction that it's all been fixed before closing at your expense, or we'll close, but we don't want to pay $1 million anymore. We know this is going to cost us $50,000, so we want to do an amendment to the agreements. We're only going to pay you $950 because we know we got to pay this extra $50,000. So you'll have that negotiation and see if you can work that out with the seller. You don't get that opportunity when you're buying from a seller under power of sale, which is the lender. The lender is not going to say, okay, yeah, you know what, we're going to fix up all those issues before closing. So that's not generally going to be an option. Whether they'll accept a reduction in the purchase price is possible, depending on what other offers they might have coming in. But remember, they also have to be mindful of their duty to have evidence in their file that they've obtained a fair market price and they went through a proper process to get there and they acted reasonably in that. Because you can't have a lender say, oh, shit, forget 50, I'll take 100,000 off if you'll close because I'll get all my money out. And I don't care if the registered owner doesn't get as much money from the proceeds because I got all my money. So, I'll sell it to you for 900,000 if you'll close in the next couple of weeks because I want to get all my money out. So that's not the approach that a lender can generally take. And excuse my foul language there. Because they have to be mindful because they do have that duty to account to everybody else that has an interest in the property. And they can be challenged, and that happens all the time. They have to show, we're selling the property at power of sale. Here's the process. Here's who got notice. They all that has to be evidence too, but they also show here's the appraisals we got. This is how we valued the property. Here's where we listed it. Here's how we exposed it. Here's how many showings we had. Here's how long it was on the property. Here's the offers we got. And the best offer we got was $950 after it was exposed to the market for a substantial period of time. And yeah, it may have been worth $1 million at some point in time, but in September of 2025, when we put it to the market was dead, and we only got $950 after exposing it for a reasonable period of time, and that was the best offer, so we accepted it. So if they've got all that in their file, there's no problem with them accepting $950. There's no problem with them accepting $900 if that's the best offer that they've gotten. They've gone through a reasonable problem. It could be $800 if they've gone through a reasonable process and they could justify it. Okay. And again, they're not going to be subject to any of those parties that are challenging and say, well, why did you sell it in September of 2025 knowing that the market was dead? What if you would have waited till the spring of 2026? You surely would have got more money. And in hindsight, when we get to the spring, maybe that in fact will be true. That's not an argument that can be open to people challenging it. The lender has the right to sell the property in the market that they're in. Okay. As long as they go through a proper process at that time when they're selling it. So they'll protect themselves that way. So again, you've got your role advising a buyer is to guide them through this and try and figure out what's a fair market price, what's a reasonable price, how old's the property? What are the potential deficiencies and defects? Hopefully you get a right to inspect, figure out all that. And you can figure out, and sometimes it's a bit of a bargain monetarily. Sometimes it may not be a bargain in price, but it just still might be an opportunity just because if this was being sold by the individual homeowner, there might be a bunch of buyers out there that would be interested in putting an offer in, but because it's being sold under power of sale, that's scaring off some potential buyers because they don't want to take a risk of the property being redeemed. They don't want to take a risk of the deficiencies that they might discover later on. They don't want to take the risk of the of an extended closing date. They need more certainty. So it just eliminates certain buyers from even considering putting an offer in on this property, which could lead to an opportunity of the buyers that have the stomach for this and have the advice and backing of a good realtor like you to help guide them through the process. So could be a bargain, could be an opportunity. There's certain risks associated. You got to be careful. You got to know what you're doing whenever you're considering buying a property under power of sale. If you happen to be, last comment I want to make, and I'll open up to questions. If you happen to be dealing with clients on the other side of this, potential seller clients, old clients that you had maybe helped buy it, and now they're struggling financially, and they're coming to you and they're saying, like, I might have to sell the property. I'm close to defaulting on my mortgage. I might default on my mortgage. I just lost my job, or I got to refinance. I can't afford this house if I have to refinance. And they're spinning and going through all of this, and they want your advice and assistance. The first thing that you should be talking to them about is um, you never want to get into a default situation. It's never good for your client to go into default and have the property sold under power of sale. The costs of selling under power of sale are going to eat away at any equity that they might have still had in the property. And you're better off, get on top of this, exhaust every opportunity that they might have to refinance the property on acceptable terms. Um, Communicate with the existing lender and let them know if the current owner is planning to sell the property, and they'll get paid out and there's enough and money that to satisfy them. Sometimes you can get them to hold off dealing with the default if you're selling the property and the property is actively being sold, because it's always better for the homeowner to sell the property themselves than to have the property be sold by the lender under power of sale. Always better for, the lender's going to get their money either way. Better for the homeowner to have control of the process. So your help and your guidance and your assistance should be to try, and if there's an opportunity to refinance and do that and keep things standing, great. If that's exhausted and the property has to be sold, it's better for you to sell it on behalf of the owner, seller, than for them to go into default and let the lender sell it. So try and push the process that way. So with that, Sabiha, I'm going to throw it back to you as people might have some questions or comments.
I have a question.
Okay.
So, so yeah, just as a where is the cutoff? Because as realtors, when we sometimes we're approached by our clients, and at this point, especially where people had taken quite a bit of private lending for closing properties in like 21 or 22 when the prices had just sped up. Um, so how do we clear ourselves to make sure that that person is still able to sell that property and the maybe the private lender is not taken over already?
Well, the private lender or the institutional lender has to go through the same process. If there's a default, they have to make demand on it. They have to issue a notice of sale. So, that's where it starts, because the owner would have received a notice from the lender saying you're in default. This is how much you owe. And if you don't pay it in the next 35 days, we're going to sell the property. That's what the notice of sale says. And not only would the owner have received it, but their spouse would have received it. It'll be served on them, registered mail or
Right.
personal delivery. Anybody else that is an interest in the property would have received it as well. So you start with that. Okay. You ask the right questions. Are you in default? Is your mortgage in good standing? No, you missed a payment. Have you received a notice? Have you received a letter from your lender? Have you received a notice of sale from your lender? And sometimes they'll say, oh, you know what? I did get something in the mail. I didn't understand what it was. I got it a couple of weeks ago. I haven't looked at it. And sure enough, it's a notice of sale and they're already halfway through their notice period and they haven't done anything about it. So
So,
as a realtor, you got to ask the right questions.
just a question about the notice of sale. If you have gotten a notice that you're in default and you know that you're in default, but the property is not being listed by the lender and it's not sold, uh, like, can you still sell the house
Yeah,
as the
you could still sell it. Now, what you should be doing is getting in touch with the lender and saying, through the lawyer, really, you should be doing it not through
Hmm.
you as the agent, but the lawyers should be involved to get in touch with the lender's lawyer and saying, hey, we're acting as this owner is actively trying to sell the property themselves. They've signed, here's a copy of their listing agreement. Here's where they are in the process. And their intention is to sell it and sell it quickly. And this is what it's listed for. And we'll keep you advised. So please don't sell it. Let us sell it. Okay. Sometimes the lawyer will get instruction from the lender saying, fine, we're going to give you a certain period of time to do it, failing which we'll go ahead. Or they might say, go ahead and try and sell it, but we're going to try and sell it too. If you get an agreement in writing, let us know, and it might stop us if we haven't sold it yet, but we're not waiting. But we have to get into a bit of a negotiation with the lender to see what they're prepared to do. And they want to see how bona fide the owner's attempt is to sell it. And, and maybe they're fine to say, okay, we're going to give you a little bit of time to do it. And failing which we're going to go ahead. Okay.
would your firm
But
deal with
they have
something
that
like that?
45-day period where they could sell it because the lender can't sell it during that 35-day period.
Um, is your firm a firm that would deal with that, or you have to go
Yes.
through litigation? Yeah.
No, no. A lot of times we'll deal with that. If we could,
Hmm.
we could start that process anyways. If it gets to the point where we got to, try and go to court and get a court order, then we got to bring a litigation lawyer. But a lot of times we can get involved and start that saying, no, no, here our client received your notice. We got it today. We got 34 more days. Just to let you know, they're actively trying to sell this property. Here's a copy of their listing agreement, or they're about to enter. We'll keep you posted. Please do not take any steps, even at the end of your 35 days, without letting us know or getting in touch with us. And as soon as we sell it, we'll let you know too. And then if we get it under contract during that time period, it's a no-brainer for the lender. We say, here's a copy of the agreement. It's closing, October 15th, and we sold it for $1 million. You'll get your 700,000 out of it. So you know please don't take any further steps. Okay, oftentimes the lender, if it's a short time period, the lender will say, fine, I'll wait till October 15th. So it'll depend on the facts at that time, but you want to try and keep them in the loop.
So one more follow-up question. So if somebody comes to us as realtors and says, oh, the lenders put a lock, change the lock on the house, is it too late for us to get in touch with Korman's or any other law firm and say, hey, we're listing the property, can you get in touch with the lender? Or
Yeah, that's a good point because sometimes the lender starts to exercise two different remedies at the same time. They might want to sell the property under power of sale, but in order to be able to do that, they want to get possession of the property because maybe they have an uncooperative owner or there might be a tenant in there and they need to be able to show the property in order to sell the property. So the lender sometimes will start an action by issuing a statement of claim which will do two things. One is they're claiming the amount that they're owed by the owner, but the other thing, they're trying to get a court order that'll give them possession of the property. So they can effectively kick out the owner or kick out the owner's tenant from the property, or get an order that compels them to have access at certain times and certain conditions in order for showings or something like that. So um, it may or may not allow them to do what you're suggesting, to be actually, in fact, change the lock. Sometimes it would, because it's given them, they have a court order that gives them possession. They're allowed to change the locks and kick out anybody and get a sheriff to throw anybody out because they got a court order. So that happens sometimes. There is a process for that as well. Again, so that's why you want to generally be upfront with a lender that's considering what options to exercise, because you don't want to not respond to things and then be at their mercy, and they're going to get an order for possession and kick the homeowner out on the street. Okay. So you want to be a little more cooperative to allow showings, whether they're trying to sell the property themselves, or they're saying, okay, I'm not going to sell the property, but I'm going to let the lender sell the property. You're better off cooperating with showings and things like that to avoid the lender taking those type of measures.
That's good. All right, it is 3 o'clock. If anybody has like a question they want to throw in quickly, otherwise,
David,
Yeah.
I got a quick question. Who typically lists the property? Is it the banks, the lawyers? Like, and where could these properties be found typically?
Yeah, it's generally listed, the lender that's selling under power of sale will retain an agent, a realtor, to sell the property and go through a process, because they're always going to sell it with some sort of multi-listing process, because they have to defend that they expose the property reasonably to the market, etc. So they're generally retaining, some realtor to
How
do
do you become that
a
realtor?
listing and sell it. And it'll show right in the listing that it's being sold by the lender under power of sale. That's who the seller is. It's Scotiabank under power of sale, or it's private mortgage company under power of sale. That's who's going to be listed as the seller. So it'll say power of sale right on the listing.
And how do you become the agent for the banks or the lenders to
you
represent?
have
Like, how do you become that
you
person?
have to get in touch with
You need good
the
connections.
connections.
You have to have that
Networking.
relationship with the lenders to
Networking.
that's a great field to be in, if you can get that and be the realtors for lenders selling properties under power of sale.
Okay.
David, what if the lender has taken possession of the property through the court order and has thrown out the owners? Can the owner sell the property or list the property at that point in time?
Be very difficult at that point for them to sell it themselves, because they have no right to show the property. Okay. I wouldn't do that or try to do that without having some sort of negotiation with the lender, saying, the owner, even though you've already taken steps and kicked them out, they still want the right to sell the property, and they've got an agent, and they've already on top of it, and they've already had showings before you kick them out, and they're seeing offers. If those are all factually correct, you might get a lender that'll agree to something, but that has to be negotiated.
Hmm. Hmm. And if I guess, well, as you say, it has to be negotiated, because I was in a similar situation recently, and the lenders was not prepared to even allow us to show the property.
Yeah, they have no obligation to. They have no legal obligation to. They've got a court order that gives them possession. They've got the legal right to sell the property themselves, and they've got possession of the property. So the only duty at that point that they have back to the registered owner is to account back to that owner once they do sell the property, in case there's some equity that's supposed to go back to the registered owner.
Hmm.
So if you're acting for that owner, you try and get ahead of this to prevent that, because they've completely lost control of the property. They've been way better off if they would have been more proactive and sold the property themselves before the lender gets the opportunity to do it.
Hmm.
Yeah, and I guess if the property is still not sold, that Pedro, you can consider getting in touch with David's team and maybe send out a letter to the lender.
Yeah, the property is not sold, and based on what the lenders are saying is that they wanna fix it up and then sell it. That they have not even, well, according to the owner, they have not yet received a notice of sale.
The
Yep.
owner has not received, if the owner had never received notice of sale, the lender would not have obtained an order to get possession of the property.
Really?
Yeah, they would have had to satisfy the judge that proper notice was given to the registered owner. So something doesn't seem right there.
Okay.
I think she needs to get in touch with a lawyer, Pedro.
Yep.
Yeah, at that point, she doesn't need my office, a real estate lawyer. She probably, it's probably too far down the road, and they might need a litigation lawyer to challenge whether or not notice was actually given to them.
Okay.
There'll be evidence in the court documents that are filed that whether the notice was served on them or how the notice was given to them.
Mhm.
All right. Thank you, everyone. Thank you, David.
Okay,
Thank you.
thank you.
Thank you.